Welcome to HR Voices, a podcast for independent HR and people professionals and the businesses they support. HR Voices is brought to you by the expert team at HR Independence Limited. We hope you enjoy. Hi everyone, and welcome to the next edition of the HR Voices podcast. I'm here again today with my lovely co-host Mary Asante. I'm Charlotte Allfrey. Hi Mary. And today we are joined by Claire Taylor-Evans, who's a partner of Boys Turner. And so hello Claire, hi.
Hi Charlotte, hi Mary, nice to be here.
What we're going to do today is we are going to talk about actually employment law updates and things that's been going on, because there's been a lot going on. We've had the sort of the lull of the pandemic where actually not a lot has gone through Parliament and royal assent. And so we are in a situation now where of April of this year, actually quite a lot has come through the system, has finally got approval in 2023 and now takes effect for employers in their policies, procedures and the way they need to operate. And what we always do with HRI is we have the ability where we support the HR consultancy network and independent sector in the UK, who are actually out there on the front line delivering a huge amount of advice to lots and lots of small businesses. And then we have some small business listeners who are looking for information, advice on how to access some of this amazing expertise that we promote and showcase, but also trying to get to grips with the legislation and the changes. So we always think it's really helpful to have an employment law update and have a professional talk to us about the changes and tell us actually what it means in practice for our businesses. So Claire, would you like to introduce yourself?
Yes, thank you. So hello everyone, my name's Claire Taylor-Evans. I am a partner, as Charlotte said, in a commercial law firm called Boys Turner based in the Thames Valley. I've been practicing employment law for as long as I can remember, well over 20 years. So I'm an experienced tribunal advocate. I spend most of my day dealing with HR directors, HR managers, HR consultants, anyone who needs advice on employment law. I also do a little bit of corporate immigration. That's where people are bringing people into the country, right to work checks, and pretty much everything to do with employment law and corporate immigration. So I'm really excited to be here today. I hope I'll be able to give you some sort of things that have come across my desk, some practical examples, and there's a lot to get through, so let's crack on.
Brilliant. Okay, thank you for that. And I think you're right, there is a lot to get through and there's been a lot of changes. So I think for our listeners today, that's why this is probably going to be one of our slightly longer podcasts. But I think it's important that we go through these things and that we get an opportunity to discuss them. So what do you think are the sort of core things that we need to be looking out for, Claire? What are the key priorities and changes for us?
Well, this year has been a bumper year for employment legislation, and that's largely because of Brexit. So we had a lot of good jurisprudence, obviously coming out of the EU, that we didn't want to lose. So the UK government made it priority, obviously, to introduce some legislation to make sure that we didn't lose that. But also we've had an unusually high amount of private members' bills as well, which have caused quite a lot of new legislation. So I thought I would start with holiday because it's complicated. So let's get it out of the way as soon as possible when we're a bit fresh. And I think what I would say is that we've had legislation in January on holiday and how it should be calculated and how it's relevant to carryover of holiday as well. And I think a lot of HR professionals are quite confused by this topic. And I think it's useful to maybe just go back to basics and then we can have a chat about the sort of areas that I think we need to focus on. So I always say to HR professionals, you need to look at what type of holiday your employees are taking. And when I say what type of holiday, I don't mean skiing or sunshine holiday. I mean, we're talking about statutory or contractual leave. And if we're talking about statutory leave, what type of statutory leave? Because what we need to remember is there's essentially 2 pots of statutory leave. So when I say statutory leave, I mean this is the leave that is statutory minimum that all employees and workers in the UK are entitled to. And there are 2 pots. The first is in relation to what's known as basic entitlement, essentially. And we sometimes call that EU leave because it's derived from the EU directive.
Yeah.
And that is 4 weeks paid annual leave a year.
Mhm.
And then there is an additional entitlement of 1.6 days leave a year. So altogether, that brings us up to our 28 days leave. And I think a lot of HR professionals don't really distinguish between these types of leave or don't really think too much about it. And it's really important. And I'll come on to the reason for that, why that is in a minute. And just to explain why we've got these 2 pots of statutory leave, it's essentially that the domestic law, when they were looking to legislate, they decided that it was necessary to legislate for these additional 8 days because a lot of UK employers were using the bank holidays as part of that leave. And obviously then some employees were only getting 12 days leave a year, which obviously wasn't the intention. So that's how it's kind of come about. Now, why is that important? It's important firstly because it's relevant to how employees are entitled to carry over leave, because we must remember that holiday is a health and safety requirement. So we must take time off, obviously. It's good for us to rest and to relax. And we need to make sure that our employees are taking that time. But there are certain circumstances where people are unable to take that leave. So, for example, if they're on maternity leave, that is a time when people are not able to take their statutory leave. So what the law says, and the law that came into force in January, which basically enshrines all of this EU law that's been going on for a number of years, it says that if you have been unable to take your statutory leave because you're on maternity or any other family leave, you are entitled to carry that leave over. Now, that applies in the case of maternity leave and other parental leave to the full 28 days. So that EU pot and also the additional pot. So that's, I think, really important to remember. The other time when you might not have been able to take holiday leave is when you've been off on long-term sick. And this happens a lot. So if somebody is off on long-term sick for the whole year, they're not able to take their leave. And therefore the law says, okay, well, if that is the case, they are entitled to carry over the statutory leave. But that only applies to the EU leave, so the 20 days, so not the full amount. So I think that's really important that HR professionals realise that distinction. Now, of course, you can choose as an employer to go further than that and allow them to carry over the full 28 days, but you're not obliged to do that by law.
I think that is a really important point to make, because I think not just for HR consultants and employers, but for employees as well to understand, because where issues arise around holidays is when an employee is totally convinced that, yes, they're entitled to these 5.6 weeks holiday, statutory holiday in the year. And if I can't take it because I'm on maternity leave or for any other reason, why can't I carry all of it over? And it's important for everyone to understand that you can only carry forward the 4 weeks, not the entire 5.6 weeks statutory entitlement.
Yeah. I mean, of course, with maternity leave, normally, and I think most people will be doing this anyway, you take the maternity leave, you take the holiday before or after the maternity leave period. But I think the sick leave, a lot of people that I've been speaking to are not aware of that. And I think the other area that I would think is worth flagging is if the employee is being unable to take leave because the employer has not encouraged them to take that leave, or they haven't flagged to them, you've got this amount of leave left for this leave year, and that can be a circumstance in which the law says, well, in that case, the employee has to have the ability to carry that leave over. And that is in respect of the basic EU leave, so the 20 days, the 4 weeks only.
Can
So,
I ask, just for clarification, so that our listeners or those watching us would know, where an employer, because a lot of HR consultants work with SMEs, and I work with a lot of technology companies and startups, and during their busy periods, people are busy trying to work to project deadlines and stuff, and so as a result, may not end up using up all their statutory minimum holiday. And what employers try to do at that point is to buy the holiday of people. So are they allowed, and can they do that legally?
no, it's a short answer. So no, I mean, obviously you are only entitled to be paid in lieu of statutory holiday on termination of employment. So it's a health and safety issue. We want our employees to be taking their leave. And so no, we definitely shouldn't be doing that in respect of statutory leave anyway. So that is a really good question.
Pay them for the additional 1.6 weeks. So assuming the employee has used up 4 weeks,
Yeah.
buy the additional 1.6 weeks from them, or is it only enhanced holiday?
Yeah, that's right.
But I think I'm asking because yes, it comes out a lot. And I think the answer is, but I think for the clarity of everyone listening, and some SME employers who may be listening, to really understand what they can legally. And
I think that's a really good question. So it applies as well to the 20 days and the 8 days, because that's the statutory minimum. If you as an employer offer enhanced holiday over and above that, so contractual holiday, well, you can say whatever you want about that, because obviously that is not governed by any of this legislation. So, and lots of employers do say, you know, you can carry over an additional 5 days leave, etc., but it needs to be taken, you know, within the first 3 months of the year, etc.
Okay, can I just ask another quick question about contracts of employment? So with that statutory or that EU statutory leave that we only allow them to carry over, do we have to have a clause in the contract that says if you're long-term sick and you will only carry over the EU leave? If we don't have a clause that says that, does that mean we have to carry all of it over, including the 1.6?
No, but what you do need to do is you need to make sure your contracts of employment reflect the law, unless of course you want to, you know, treat them more favourably. So we would always recommend that you have something in your holiday clause in your contract of employment that sets that out, and also your holiday policies. Yeah. Because the other complication, of course, is that you as HR and the employee don't know what pot of leave they're taking. So what we always say is, you know, you take your statutory leave first and then any contractual leave after that, so that at least then everybody knows where they are with the leave, which is really useful. The other thing I would say is to just make sure that you have a process in place, that you are encouraging your employees to take leave, that you've got records and you can flag coming up to the end of the leave year how many days there is outstanding, so that you don't then have any argument from an employee saying, well, you didn't allow me, I was unable to take that leave, and therefore I would like to carry that over.
I think the other thing, practical application from that, is also the fact that you don't want an employee to work all year long and suddenly decide in November they are taking the entirety of December to mid-January off because they've got so much leave left. So it's quite important to manage it from that angle anyway, from operational efficiency point of view. And in terms of systems of managing your holiday, there are some really good, relatively affordable systems out there that employers can use. And so the good old spreadsheets, if you don't have any system at all, can be, I mean, that is harder to manage and requires more manual effort. But there are definitely systems out there that employers and HR consultants and HR professionals can use to manage holidays. Yeah,
absolutely. So that's the sort of carryover requirements. Oh, the other thing I would flag is that way back in COVID times, which we've all now blanked from our memory because it was so horrific, but you will remember that there was an ability to carry over holiday leave the government introduced if it wasn't reasonably practicable for you to take it at that time. So that's obviously now been repealed, and anything that hasn't been taken by the 31st of March now has been lost. So there's no requirement on you as employers or HR professionals to advise their clients to pay in lieu of that leave. It's basically gone. So the other area where these pots of leave and the distinction is important is in calculating holiday pay. And we have had a huge amount of case law on what should be included in holiday pay. So just to remind everybody, the requirement now, which has been enshrined in legislation, is holiday pay needs to be including all normal remuneration. So everything that is linked to the contract of employment, the performance of the tasks that the employee is obliged to carry out under that contract. And also payments such as overtime payments, which have been regularly paid to the worker, commission, etc. So I know when the case law on this first came in a few years ago, a lot of my clients were saying, what should we do? And we were advising of the risks, but they weren't necessarily the situation. And we were very much, well, let's wait and see what happens, but we need to obviously undertake an audit. This has all changed now. So you need to absolutely make sure that you comply with this legislation and that you are auditing and making sure that you're making those payments properly. I think another thing to bear in mind is that only applies to the 20 days, which is another area where we need to look at that distinction. But obviously, it's a bit of a minefield for HR to work out, you know, we're only going to pay those 20 days at this amount and the remaining at this amount. So some employers will just pay the whole amount, obviously, including that. What other good things have we had in January? We've had some clarity on rolled up holiday pay, which is great because I always get calls from people with irregular hour workers and how do we work out their holiday pay? And of course, the proper way to do it was to look back 52 weeks and then work out what they earned, etc. And this was really tricky for HR, really cumbersome. So a lot of them would just say, well, look, I'm just going to roll up the holiday pay and I'm going to apply a percentage and that's how I'm going to do it. And courts didn't like that. So in 2006, that practice was outlawed, but everybody kept doing it anyway, in my experience. And I had to constantly say, you shouldn't be doing that. So this is really welcome news now that this legislation is saying you can do that. We understand that you're busy HR professionals and it's difficult for you to do this. So we will allow you to roll up holiday pay at 12.07%, provided you are really clear and transparent on the individual's payslip. So you need to make sure that you specify very clearly what part of that is holiday pay. So just some action points, I think, just to kind of sum up, check your holiday year, have an audit, make sure you are actually including in your holiday pay what you should be, because obviously the whole idea is employees shouldn't be penalised for taking holiday. So if they're not able to earn commission because they're on holiday, then obviously that needs to be included in the holiday payment, and make sure that you're doing that. Make sure that we're reminding staff it's use it or lose it. You need to take this holiday to avoid any risk of claims there, that they can carry it over. And update your policies and your contracts. Make sure that they are now compliant with the legislation, because that's really important. So that's holiday pay.
Yes, great advice on all of those things, but I'm sure that advice will probably be the same for all the other things we're going to talk about as well, because I know I'm definitely in handbook heaven or hell, whichever way you want to describe it at the moment.
I know, yeah. I was joking about holiday pay, and I was saying one of my biggest pieces of advice to HR is don't take any holiday. You're not going to have any time. You've got to get on with all these policies.
I think the piece about encouraging employees to take holiday is really important, and I can't emphasize it enough, especially in busy working environments. Very important, because the employees typically will turn around and say, hold on, I didn't take my holiday because I was busy working on this deadline to this project, etc. And they will be justified. So it's very important. And sometimes they almost feel like taking the holidays letting their team or the employer down.
Mm.
And so it's quite important to have that policy, that culture that encourages people to take holiday, like you're saying, from their health and safety, and also from their well-being point of view. One of Charlotte's favorite saying is, you can't pour from an empty cup. So for the employees to be more productive, to be functional, etc., they do need that downtime to be able to function properly and be more productive.
Yeah, I think that's really important. And I think, you know, as managers as well and leaders, it's really important that you are creating that sort of positive role model and taking your holiday yourself as well, making sure that your managers are all doing that, because it is really important, particularly with our sort of mental health crisis we've got at the moment in the workplace, and you know, the difficulties that we're facing. Absolutely.
Great stuff.
Okay, so what else have we got?
What else?
Away up your sleeves.
we got lots more, Charlotte. We got lots more. So what else did we have in January? So right to work fines. So it used to be the case that if you were inadvertently employing an illegal worker, you could be faced with a fine from UKVI of up to £20,000 per employee. That was tripled to £60,000. And so that's particularly if there's repeat breaches. So that's really important. So make sure you're up to date with right to work checks. I can't emphasize enough how important this is, because I've seen so many issues with it going wrong, and businesses not only facing the fine, but the reputational damage. Also, businesses who sponsor migrant workers losing their licenses, businesses who want to sponsor migrant workers finding that they can't then because they're barred from actually applying. So it's a really big area, and I think if you do outsource it, you need to make sure, because it's the employer's obligation, you need to make sure that you are checking that is done properly and that you are recording the date, etc., on the right to work check. So training and awareness on that is really key. But skipping forward now from January, we'll get to April. So we had some more changes in April. So the first of those was changes to the paternity leave regulations. So it used to be the case that you could take paternity leave, but it was really restrictive in the way it was able to be taken. So you could take 2 weeks, but it had to be basically in one go. You couldn't take 1 week when the baby was born and then 1 week later on. And that wasn't great for fathers. So that's good news. I think that we've seen that change. So now you can take a week when the baby's born, and then another week, if you like, within the first year of the baby's birth. The notice of intention to take leave has also changed. So that has changed from 15 weeks to 28 days, which again is good. But what hasn't changed, and as you know, Mary, I'm very passionate about sort of gender pay, reducing the gender pay gap and
absolutely
equality and diversity. What hasn't changed is obviously the woeful statutory rate of pay that you know most companies still pay, and obviously the 2 week period is just, in my opinion, not sufficient, because I think that time is so important from a sort of bonding perspective. There's all sorts of studies about how positive it is for fathers to be involved in the early years of a baby's life. So I really do, I mean, obviously this isn't a political rant, but I really do think that we've got some way to go there, particularly looking at, you know, across the EU, looking at some of the parental policies in Iceland, for example, fantastic, you know, really progressive, and they have got a minimal pay gap. And I think that is a really big feeder into that.
Yeah, and I would totally agree with that, because if you look at shared parental leave and the practical uptake of shared parental leave, it's still significantly skewing towards women, isn't it, who take leave or parental leave as opposed to most men within the workplace. And I know there are various genders in between, but I'm just taking the extremes of genders because that clearly illustrates the pay gap better. But yeah, it's still heavily skewed towards women. affects, and invariably it does affect your career, and it does affect your promotional opportunities and pay, and increases the gap. So I definitely agree it needs to be addressed.
Yeah, absolutely.
And I don't see really why, if we're bringing the limit, or expanding the limit up as to how long they can take it, that's great. But actually 2 weeks in a year is nothing really, is it?
No.
And it would be nice to think that perhaps if they did take some of that leave within the first 6 weeks, that perhaps they would get the 90% pay the same as the women, so
Yeah.
it would be comparable. I mean, I know going back quite a few years now, but, for us as a family at the time, it's just prohibitive in terms of the amounts of money, and it drives you towards a direction of going down the traditional model because that's what you have to do financially.
Yeah, I think so. I mean, we are definitely getting better. I do think that, I've seen examples of really good positive change in employers where they're encouraging men to take parental leave, where they're paying enhanced parental leave. And I think that's all really good, but it will take a long time to change. And as you say, Charlotte, if it doesn't change, then it becomes self-perpetuating because the woman will take a step back because they feel that they need to limit themselves in some way because childcare costs are extortionate and they can't commit to the sort of long hours that they might otherwise have been able to do. And then their salary obviously stays at a certain level. The male increases and progresses and gets promoted. And then it just doesn't make then financial sense, if there's particularly even after childbearing years, the woman then may need to care for elderly relatives, for example. It makes more sense for her to do that caring if her sort of salary potential is lower, and it just carries on in a cycle. So yeah, I think there's a long way to go. And I was looking at some surveys from some organizations that said 70% of fathers did not take their full entitlement because they couldn't afford to, and only 29% of fathers had access to enhanced paternity leave or pay through their employer. So, we're getting there, but we've still got quite some work to do, I would say. Right, moving on. So that was paternity leave. So nothing really too dramatic there. But what we did then have is a new right for carers leave. And again, I think this is really important because there's estimated to be 5 million adults unpaid carers giving care to dependents at the moment in the UK. So it'll be interesting to see whether that is reflected in the uptake of this leave. What I would say is that this leave is unpaid. It came into force on the 6th of April. It is a day one right, so you don't have to have any qualifying length of service. And there's a really wide definition of what a dependent is. So essentially, a dependent is somebody who has a long-term care need, physical or mental illness or injury where it's expected to need care for 3 months or longer, or a disability or care needs because of old age. So that is a really wide definition. And the people who can take this leave are pretty much anyone who needs to care for a dependent other than, so it's somebody in the same household, or unless they are essentially a lodger or a tenant, which is interesting because you may well live with somebody who is a dependent as a lodger or a tenant, but they are specifically excluded. It is only 1 week, regardless of how many dependents you have. So 1 week per employee. And it can be taken in all sorts of configurations. So you can take, a half day here, or you can take a block of 2 days, etc. There is notification requirements that say that you have to give 3 days minimum notice or twice the length of the number of days you want to take. So if you wanted to take 3 days, you'd obviously have to give 6 days notice. It is, I think, going to be an area that we need to make sure that we've got policies in place for, so that we are up to date with legislation, and also that we are training our managers as well to make sure that they're fully aware of it. You can't refuse if somebody comes and says they want to be able to take this carers leave, you can't refuse it. but you can ask them to take it at a different time. So if there was a serious disruption to the business because of their request, you can say, well, actually, we would like you to take it at a different time. And like with all statutory rights, the individual can't be treated less favourably as a result of having asked and can't be subjected to a detriment. So I think it will be interesting to see. Obviously, we do have some right for people to take time off to care for dependents at the moment, but it's only 1 or 2 days and it's unpaid, and it's really just for emergencies. Whereas this is meant to obviously allow them to take time off to care, but not in an emergency situation.
Yeah, I think that's where there's been quite a bit of confusion actually as to whether the carer's leave has replaced time off for dependents leave, or sometimes called emergency leave, because it hasn't. And I think the key difference between the two is that definition of long-term care.
Yeah.
And also to provide the care as opposed to make arrangements to, you know, because your care arrangement has suddenly dropped out, you know, the school's closed, the nursery's closed, your carer doesn't turn up, something like that. So I think that's where there has been some confusion, but one doesn't replace the other. They are both there, but with different purposes.
Yeah, absolutely. So I think that really an action point is make sure you update your policies, make sure that's in place now, because that came into force on the 6th of April. And what is interesting about this leave is that you can't ask for evidence. You can't ask if, you know, and so there is, you know, some concern, I think, well, will this be exploited? But it's a week unpaid. So I think there's not really going to be much.
I think as a carer myself, that is where probably, like most statutory legislations, it's all well and good, but people may not end up using it because it's unpaid. And the fact that it's unpaid, yes, I totally understand that the funding for that will have to come from somewhere, and all of us as taxpayers will have to pay for it. But that can also be a huge deterrent because, like you said, there are over 5.4 million unpaid carers in the UK, and already they are sacrificing quite a lot to care for their loved ones. So to be able to take a week off is great, and in some cases you do it anyway. But the fact that it's unpaid means that where cost of living is high, people are under huge financial pressures and everything else, it will be interesting to see whether people actually make use of this particular sort of leave or revert to using annual leave to care for loved ones.
Yeah.
I'm also interested though in this idea of they're not having to provide proof or evidence, because you know, it's particularly in smaller businesses, they will want evidence. You know, they'll want to know that somebody is taking the leave for a genuine reason, and they probably are, but there might be some out there that might not be. You know, it's sad that the minority sort of damages things for the majority that are doing it for genuine reasons. But I know definitely with some of the small clients that I work with, they'll be sort of saying, well, why can't I ask for information and evidence that they can take that?
Yeah, I mean, what we've been saying in our policies and given to our clients is a self-certification form essentially for the employee to complete. But yeah, you pretty much have to take it on face value that they are obviously caring for these dependents.
Yes.
I mean, it must take a very desperate person who isn't caring for anyone to say, look, I'm going to take a week off throughout the year and pretend as if I'm caring for someone. I'm very desperate to be able to do that.
Particularly as we say, it's unpaid. So, but I mean, I think it's good that, you know, we do have that option for people who have that genuine need, which is great. The other thing that came about in April, of course, was the extension to protection for redundancy in relation to people on maternity leave and pregnant employees and people on shared parental leave and adoption leave. So up until April, the only protection really that was in place in a redundancy situation, and I'll qualify what I mean when I say protection in a minute, but was in relation to if an individual was on maternity leave or shared parental leave or adoption leave, but actually on the leave. So they were protected whilst they were on the leave at that time. And I've always thought that was really bizarre, because in my experience, when an individual returns to work after maternity leave, that is the risk area, because the business has done without this individual for a year, and they might find that they've done without her and they've been just fine. And that kind of then highlights, or maybe we don't need this role. So I think that was always the risk factor. And obviously the government agreed to some extent, because they have now extended the redundancy protection. So currently, the redundancy protection no longer applies just whilst they're on the parental leave or maternity leave. It applies from when the individual notifies their employer that they're pregnant, right through until, essentially, if they were to take, say, a normal 12-month maternity leave period, 6 months after they've returned, so 18 months after the baby's born. So you can see how that has widened out the protection hugely. And when I talk about protection, I'm not saying they can't be made redundant, and I think that is a common misconception. You can make people on maternity leave redundant. You can make pregnant employees redundant. You can make people on shared parental leave and adoption leave redundant. But essentially, they will get first refusal on any suitable alternative employment that is available in a redundancy situation. And that is the protection. And they have the entitlement to be offered that. It's not just, would you like to consider this? They have the entitlement to be offered that suitable alternative position. Now, I can think of a whole host of issues with this, because up until now, if anybody's going through a redundancy scenario, I've always said, you need to think about your people on maternity leave. But now you have to think of your people who are pregnant, your people who are on maternity leave, your people who have come back from maternity leave in the last 6 months, So it's really key now, I think, for employers, particularly if they're going through a restructuring exercise, to make sure that they have proper records of which categories of employees might be impacted, how they are protected, so that you can flag any issues that might arise.
A lot of the time, it's up to the employee or down to the employee when they inform the employer that they are pregnant. And so when an employer is thinking about restructuring, we all know that it takes a while before the wider workforce become aware, because of all the underlying background work, building the business case, etc., exploring how you might avoid the redundancies altogether and all those sort of things before the employees become aware of it. So when somebody or when an employer has initiated restructuring, unaware that somebody is pregnant, how would you advise that? Because it probably might be through the consultation, or they may never actually find out that an individual is pregnant. And so the person probably goes off and discovers that, oh, because I'm pregnant, you have to give me this first opportunity of an offer compared to my colleagues. So if a complex situation like that arises, an employee then comes back to say, hey, by the way, I'm pregnant, what should the employer do?
Well, I mean, if you're on notice, obviously they're protected. So, if, and it doesn't mean, of course, that you can't pool them in a situation. They're not excluded from the pool. I think, again, that's a common area of confusion for employers. You can put somebody in a pool, but then obviously if they are then at risk of redundancy and there is a suitable alternative employment available, they would essentially have priority to be offered that. And I do think, your point on notification, Mary, you may find that people, I think most people would, tell their employers after the 12-week scan generally. You may find employees, telling employers sooner than that in the future, because particularly if they sense, there's something going on in the business, I want to ensure that I'm protected from this stage right now. So we may well see a bit of that. But the other area that I foresee lots of problems is, because there is such a wide protection now and different categories of employee, what happens if you've got a suitable alternative employment but someone on adoption leave, a pregnant employee, someone on maternity. I mean, it can happen because we've been, you know, there's so many more categories of protected employees now. And
so what do you do in that scenario then?
well, this is the interesting question, and I have this question quite frequently, and I think the answer has to be, obviously you can't offer it one job to all of them. If it is genuinely suitable for all of them and they all are all protective, I think, and there isn't any legal precedent on this yet, you would have to go through some kind of fair and transparent process to ensure, you know, that you aren't at risk of automatic unfair dismissal. But I do think we'll get quite a lot of legislation in this area coming through the tribunals.
It's going to be interesting to watch, isn't it, actually? And I think something else that is always a point of discussion is actually what is a suitable alternative and what isn't. And, you know, there's always a lot of debate around that. And yes, you must offer them a suitable alternative, but, you know, some employers will say, but no, it's not suitable for them. And so it's working through that with clients to explain why we think it might be suitable, and, you know, looking at skill set matches and not thinking about a person or you know, well, that's the person that does that role, so they should go because that role's going. Actually, we have to look at, you know, other people in the pool and all those other things. And that's where the debate sort of starts to kick in.
Yeah. And, you know, it's also not about creating a job as well and making sure that this is only really if there is other roles available and they are suitable. And you know, suitable alternatives, it is an objective and a subjective test. So there's so many factors that come into play. So I think that is going to be really an area to watch, and hopefully we'll get some case law, some precedents that help us in that situation. So just in relation to that, I think action points are train your managers, make sure that they're aware of this, because it's really easy to get this wrong, because obviously if you do, the individuals that have claim for automatic unfair dismissal and discrimination potentially, and also making sure that you're recording all of these individuals who are on leave and the length of time that they are protected from for. What else do we have in April? We had the changes to the flexible working laws. So it used to be the case you needed 26 weeks service before you could put in a flexible working request. We now know that applies from day one. Interestingly, the ACAS guidance that was published around the time recommends thinking about flex working even when you're scoping out the job. So even before the, you know, the day one, right? And they say that this increased applications in studies where this was done by 30%, which is interesting. The other thing that's changed with flexible working is now we get 2 requests a year instead of 1. Which means more work for HR, because you obviously need to make sure that you're recording that and dealing with that. And also the time limit for dealing with it has been shortened. So from 3 months to 2 months. So nothing else really has changed in terms of your obligations as an employer, because you still need to obviously consider the requests and deal with it in a reasonable manner, which is always the case. You still have the 8 statutory grounds for refusing the request. You do need to consult with the employee now, which you didn't have to necessarily before rejecting the request. But I think really the action points in respect of that is again, training, very important, update policies, making sure that you are timetabling these things, because 2 months isn't very long, really, to deal with flexible working requests.
No, because that includes the appeal as well, doesn't it? So that's the whole process. So by the time you've met with someone, consulted a bit, you know, or even then tried to put a trial in place or come up with different options and agree, and then maybe not agree and there's an appeal, that moves quite quickly.
It does. I mean, you can agree to extend the period, obviously, with the employee. But that's only if they agree. And so, yes, you do need to be mindful of that. Of course, you don't have to offer an appeal, but I would certainly recommend that you do that. And the ACAS code strongly advocates that you do as well, and offers the right to be accompanied at any meeting.
Yeah, and I think, is it right now that you don't have to provide much of a justification now about how your role will be covered as well? So it's more for the organisation to determine the impact.
That's right. So it used to be the case that the individual would have to say, well, this is how I foresee the business dealing with this, and put forward proposals and suggestions. No longer is there a requirement for them to do that. And I think the direction of travel in this area, particularly if we see a Labour government at the next election, is there will be much more focus on this, to the point that employers will be expected, I think, to agree to a flexible working request unless there's a very good reason not to. And I think we will definitely see a change in that. So the more we can do now, I think, as employers, to educate our managers and think about this, the better. Because I do think that we will see lots more legislation in this area.
I can already feel and see with my crystal ball some of my clients having a bit of a purple fit about that, about being required to agree.
Yeah.
You know, particularly in the small business sector and the micro business sector.
Yeah, well, I mean, it's interesting. I was looking forward at some of the proposals that Labour had set out in their manifestos, and yeah, they were essentially saying there would be a new employment bill within 100 days of the election. Lots of proposals to improve work-life balance, as I say, about this agreeing to flexible working requests, pressure on employers, day one rights, so unfair dismissal rights from day one. I mean, that will be a huge overhaul if that obviously was allowed to proceed, and removal of the cap on compensation for unfair dismissal. So yes, I mean, I think, and obviously a huge focus on transparency and fair pay. They've already said that they will introduce mandatory ethnicity pay gap reporting, potentially taking more steps to give the gender pay gap reporting regulations more impact, because at the moment, obviously, if you've got a gap, you don't really have to do anything about it, unlike in Europe when you have to take remedial measures under the EU Pay Transparency Directive. So I really do think that there will be a huge shake-up and more employment legislation for us to talk about if Labour come into power. And also, of course, then we've got the consultation on introduction of fees again in the Employment Tribunal.
Yeah.
So that will be interesting, because we had that, as we know, 5 or 6 years ago, when you had to pay £1,000 to issue a claim. The proposal now is £55. And the reason that fees were abolished was because they felt that the Supreme Court felt that the level was disproportionate and prevented access to justice. I'm not sure that they would take the same view, obviously, of a £55 fee as opposed to a £1,000 fee. So watch this space on that as well. Never a dull moment in employment.
No.
I mean, I think that's definitely, I think the fees before were classed as prohibitive, and obviously a small fee like that isn't. That's more of an admin fee, isn't it? And I don't think that would deter people from putting something in.
Yeah, absolutely. So that's all of the law that's sort of come into play to date, and I've kind of talked a little bit about what I foresee as well. There are also proposals for neonatal leave, as we know, coming into force in April 2025. Again, that would be a brand new right, and I think that would be good, because obviously if people are in a situation where the baby is born poorly, often at the moment employees have to take annual leave, or they take maternity leave, and they exhaust that very quickly, obviously, if the baby has to spend any length of time in hospital. So the idea, this would be in addition to any maternity leave. So we await further guidance on that, but just something to flag and be aware of. And then we've also got potential changes to the law on sexual harassment, and employers' duty to take reasonable steps to prevent sexual harassment in the workplace in October. That's planned to come into force. And it's quite interesting because it's going to raise the threshold, I think. So at the moment, as we know, as employers, you get a statutory defence if you train your managers and your employees that they mustn't obviously sexually harass people in the workforce. And then obviously if somebody does and you get sued, you can say, we've got the statutory defence. But just to say that statutory defence is only useful if you've undertaken the training recently, that you've kept it refreshed, that you've made sure that it's all up to date, it covers all of the protected characteristics, etc. This is now taking it slightly further, saying that you are, rather than just having this defense, you now as an employer have to take a proactive duty to take reasonable steps. And again, it's going to be all the same sort of thing, but making sure you're reviewing your policies, making sure you're training your managers, etc. So we're awaiting further guidance on that, but I think expect that to come into force in October.
Yes, and of course that didn't include the third party, the reintroduction of third party harassment, which I think it was asked to do, but that didn't get added back in.
That's right, yeah. So there was a terrible case years ago with Bernard Manning and making terrible remarks about waitresses in a hotel. And then we did have this third party harassment came in, then it was repealed. And as you say, Charlotte, correctly, there was certainly in the draft proposals that this would be reintroduced, but it was actually removed during the reading process at the House of Lords. They didn't feel that they wanted to reintroduce that at this stage.
No, I think that would be quite tough for employers, wouldn't it?
Yeah, it's very difficult to manage, very difficult. I mean,
Mm-hmm.
at the moment, I see lots of my clients, particularly in the sort of service or retail industries, with the notifications about not harassing our staff, etc. But it's very difficult to do much more than that, really. And then what else have we got coming up? So we've got the new code on fire and rehire. That's due to come into law in the summer. Not really any changes here. This is just in relation to the dreadful case with P&O, if you remember, with P&O Ferries, when they basically sacked all their staff and then employed a load of agency workers. What this is saying now is that you need to obviously act reasonably. If you're going to make any changes, you need to consult. There's all sorts of requirements in relation to obviously making changes to terms, etc. So sort of same, it's common sense and what reasonable employers would be doing anyway, I would hope. So yes, and then we've got potentially in September 2024 the right to request predictable working hours, which is essentially a reverse of the flexible working request. So very similar, that employees who are on perhaps 0 hours contracts can say, I want a more certain working pattern, and employers would have to consider that.
Yeah, that's going to be quite interesting because that's obviously going to address some of the 0 hour working challenges, isn't it? Yeah, those that don't get regular hours. Yeah, so my goodness me, that is a lot, isn't there? There's a lot. There's a lot been going on.
Stop tour there through everything.
And actually, also the more important increase in national minimum wage, isn't there? From the beginning of April, which SMEs are kind of crying about the increase.
Yes, of course, the drop in the eligibility age as well. So that's been quite significant, hasn't it? Cost-wise.
Yeah.
Well, no wonder we're all busy.
That's right. And then obviously the tribunal compensation awards were increased as well to I can always remember this off the top of my head, 115, which is a very handy figure. So yes, lots of changes on the figures as well.
Brilliant. Well, thank you very much for that whistle stop tour, because actually I think when you do it in this sort of way, actually it if you give people the headlines, then we can get down into the detail when we need to, but it's just helpful to understand the top line changes and what the impact might be. And I think, as many of our listeners will know at the moment, that updating policies, procedures and processes is where it's all at the moment, to make sure this is all understood, and obviously training those that make decisions and put policies in place of how they operate is all part and parcel of that. So a huge thank you for doing that. Very informative, very helpful. Obviously, to our listeners, there's a lot to put in place, but hopefully that's given you a really good flavour and a good head start. If you're a small business listening and you want some help, there is an army of HR consultants out there which you can find. The HRI website can help you with that, with our directory. And we probably will be able to help you find an HR consultant or people practitioner who will be able to help you put some of that in place. Thank you as ever for listening, and we will hope to see you and speak to you next time. Thank you very much, Claire, for joining us and for your expertise. Much appreciated.
Thank you.
And thank you, Mary, as always. It's been a pleasure, and we will see you next time.
Thanks.
Thank you.
Bye.
Bye.
We hope you enjoyed this episode of HR Voices. If you have a topic you'd like us to cover or would like to be a guest, we'd love to hear from you. Connect with us on social media or email us at hrvoices@hrindependence.co.uk. Tune in next time.